Now, it is we heavily submit that in making a decision in this matter, the court puts emphasis on obedience of orders of court, because all of us are equal before the law. We are alive to the fact that the accused person is a sitting member of parliament. But when it comes to treatment before you and before the law, we all should be equal. When it comes not only in court but also in administrative action in any office. So in conclusion, Your Honor, we want to state that and submit that the court has that power and discretion to deny bail under Article 49, one head of the Constitution, Your Honor. And we have the Honorable Court, even as the court retires, to consider this, to keenly look at the proceedings of the court, because it's even the court file, the original court file is still within the registry or the archives of the court. The same way we request that the same be retrieved for you to consider in your ruling. Your Honor, that will be all I will want to give.
Your Honor, I'll be brief. Your Honor, I'll start by saying that the foundation of bail bond in Kenya is the Constitution and the Criminal Procedure Code of 75 laws of Kenya. Article 49(1)(h) of the Constitution states that an accused person has a right to be released on bail bond on reasonable conditions pending a charge or a trial unless there are compelling reasons not to be released. As said further, Section 123A of the CPC that sets out exceptions to the right to bail on bond. And this section is brought on board to align with the Constitution. And it provides, if I may read briefly, that subject to Article 149(h) of the Constitution, and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all relevant circumstances, and in particular, A, the nature of the seriousness of the offense, B, the character, antecedent, association, and community ties of the accused person. I will not read all of the other parts. I will stick on the antecedent of the accused person. The bail bond application primary consideration must always be whether the accused person will attend court. And as has been submitted by my colleague, Mr. Kilwan, I'm not going to repeat. He has demonstrated to the court how many times the accused was not able to failed to attend court. And now what I'm inviting the court to consider is the antecedent, the conduct of the accused disregarding the court orders. Your Honor, the accused person did not even attempt to account for that period that he did not come to court. And therefore, the possibility of him absconding is not far-fetched. The prosecution has no other issue with the other grounds that have been raised under Article 49H. We are aware that the accused person is a member of parliament and he has a constituency to serve. His constituents are waiting for him. But only one issue that we have with the accused person is whether will he attend court should this court release him on board. And the fact has been laid before you, Your Honor. And lastly, Your Honor, there is an order for anticipatory bail that was placed before you yesterday. And I would like to submit, Your Honor, anticipatory bail was given because the accused person had not been charged, was anticipating arrest. But the law provides that whenever...
Maybe just to confirm, that is not correct. It's just a small observation. By the time that application was being made, the accused person had actually been arrested. So it was not anticipatory. He had been arrested. And the order is for his release after arrest. So it was not pending arrest. Just for
I'm guided, Your Honor. It was not related to this case. Such that no order from the High Court that pertains to this case is before you. What counsel has submitted is true. He was arrested and it was given an order in that particular case. So what I'm saying is there is no such orders for bail in this particular court from the High Court. So we submit that we are opposed to the release of the accused person on bail, and we will wait for the court's ruling. We are most welcome.
Mr. Senator, we will first make a
in a very brief response, perhaps after my submissions, we will have Inspector Ian Kapakuli, but pursuant to the order that we have sought to come and raise himself for cross-examinations. However, I would like to make the following remarks. It is not true that the previous case, that is criminal case number A715 of 2021, was withdrawn as a result of the accused person having absconded. Your Honor, to this, we only need to look at the type proceedings that are attached to the application at page 14. And what the proceedings need is that the cash bill has been forfeited. I therefore pray, this is the DPP talking to court. Since the cash bill has been forfeited, I therefore pray that the case be withdrawn under section 87A of the CPC and the warrant of arrest to remain in force. So it is not true. It was absconding that led to that. It is the DPP in his own position who came.
The quorum, what does it say?
The
quorum.
Is he present or absent?
He was
No, we don't go around this.
that is beside the point. If the reason was since he has absconded, we are seeking to withdraw that on record. It is the DPP who came and said we wish to withdraw the case under section 87. So let us not feel in the proceedings what is not in the proceedings. Then, secondly, it is also not true that the accused person is before you today or was presented yesterday having been arrested pursuant to a warrant of arrest. He was not arrested because there was a warrant of arrest, as submitted by my learned friend. To that, Your Honor, you only need to look at the charge sheet, the face of the charge sheet. And there's a part where that table where it asks, arrested on 18 February 2024, with or without warrants, it reads without. So it is not true he was arrested because there was a warrant. The charge sheet is still for the absence in the previous case which has been talked about, Your Honor, there has been no forum for him to come and explain why he did not attend court on the same dates. The case was withdrawn, so that forum ceased to exist. Even after he was arrested, he has not been given an opportunity to explain his absence. So it's not true that he has not explained. This is as I don't want to overemphasize, we know that Parliament sits 3 days in a week, Tuesday, Wednesday, and Thursday. And these are members of Parliament who, on a weekly basis, is available in Parliament. If someone does not attend 8 consecutive sessions of the National Assembly, he loses his parliamentary seat. So therefore, the weight that would be placed on him absconding court versus losing his parliamentary seat, losing the parliamentary seat far outweighs the need for the urge to not return. Other than denying bail, Your Honor, the court has several modes of putting bail conditions that will ensure a person can compete. There is a submission that the accused person is not fit to be admitted to bail. His fitness to be admitted to bail. Your Honor, that question is moot because it was dealt with by the High Court in High Court Criminal Miscellaneous Application number E028 of 2025, where he went and made an application.
Your Honor, we object. That we don't know. It's just a new area. Then we require to respond. Let him not.
Your Honor, this is what was called anticipatory order. So I don't know.
But the case.
The order has a case number at the top.
The authority you are alluding to.
No.
We do not have it.
Okay,
Yes,
maybe.
Yes,
If Emmanuel and friends can just be calm, just give me time.
Today I'm calm. I'm just saying, do
I'm
not
just-
raise a new authority that we did not allude to when we're submitting.
Your Honor, let me just demonstrate.
We should submit on the price of lawyers.
Actually, and the reason why we are told to withdraw the madness at me is to avoid this. So it's better you address the court. Okay, it's better you address. Please talk. Your colleagues here, your colleagues outside, can't run away from it.
My apologies.
So please address the court. Don't address each other, so that we don't.
My apologies. Your Honor, on 18 February 2025, the accused person made an application in the High Court in Kiambu. That's a High Court Miscellaneous Application number E028 of 2025, where he sought to be released on bail.
Alright, did you raise that? I'm trying to see. Did you mention that case?
I did not mention it, Your Honor.
So, I don't know how you
Your Honor, if you may allow me just weigh in because I like it participating and then I hand over. That order that is before you, which triggered you to admit our client to bail yesterday, has a basis. And that's what counsel is attempting to lay the basis. Because when he was arrested, and I think I was the first person to ever interact with him, counsel, he was arrested for a different reason that brought us before you yesterday. He had been arrested, just to give you off the record, he had been arrested allegedly for committing a cyber crime through his verbal pronouncements. When they realized that that one would have no basis and did not attach, that's when they resorted into now this mischief. You know, if you allow counsel to lay the basis for I am on my feet, counsel.
I know you're on your feet, but using the word mischief in a matter which has been burning from 2021 is unfair to the DPP.
Okay.
Your Honor, the word receive is an English word.
No, it is.
And
but
more so, Your Honor, it is a word that is somewhere provided for in the Blackstone Dictionary. But if they feel offended, I'll
Use
not
another
use
word,
this.
please. Don't call
You know,
them.
allow counsel to lay the basis of that order, so that Your Honor, then you can be able to square out
Okay.
where the office of the DPP is attempting to abuse their office.
Alright, I want Wakili to couch it in a very soft manner.
Very well.
Please don't attack them.
I will not.
They are simply doing their job.
Yeah, Your Honor.
So couch it in.
Yeah. We may not have to write it for written. There was a submission that the person is not fit for admission to bail. That's what I was speaking to. And my submission is that his fitness to admission to bail has already been determined by the High Court. In High Court Criminal Miscellaneous Application number E028 of 2025.
Your Honor, I don't know whether we'll get a chance to respond to this.
Yeah, this is peculiar. I just give you a chance. It's possible. Otherwise, you just tell me.
Your Honor, the accused person, on his arrest, before he was brought before you, obtained a court order for him to be released on cash bail of 200,000. And Your Honor, graciously yesterday he was released on those terms. I'm not speaking to the terms of the bail. I'm just speaking to, is he a person who a court of law can admit to bail? And the High Court has already found that is a person who is fit for admission to bail. And the court went ahead, set bail terms, and he complied with the bail terms. Therefore, he is not a person who can be said to be unfit to be admitted to bail. Lastly, back to Article 49, we start from a position of Article 49, sorry, 49. You know, we start with from the position that when an accused person is presented before you, he has an inherent right to be admitted to bail, so that anything other than that is a limitation to that right. So what the prosecution is asking you to limit that right for the reasons that they have provided. And as we have demonstrated, those are not reasons enough to limit that right to an accused person. I therefore pray that for the purpose of dealing with the facts, you make an order that Inspector Ian M. Makumi be present for cross-examination.
Yes,
And that application is not opposed in any event.
just before that, Your Honor, allow me to just submit on 2 points of law in respect to the application to deny bail to the accused person. Your Honor, just beginning from where my learned colleague has stopped, is that the limitation of a right under 49 must be justified under Article 24. And the test under Article 24, Your Honor, when assessing whether these are compelling reasons that would warrant the limitation of that right, you look at the test of one, is it justified in a democratic and civilized society? That is the test. When you look at the question of the test, whether it is justified in a democratic society, Your Honor, look at the position the accused person holds in the society. That is a democratically elected person, serving member of parliament, required to exercise the sovereignty of the people under Article 1. And therefore the question is, if the right to liberty is limited, will he be in a position to serve? And is it a justified limitation in a democratic and civilized society? Number two, Your Honor, when these matters were brought before yesterday, the first objection we raised was that we do not need to have a separate file. Our objection was overruled and we accepted with humility. And guided by the wisdom of the court that led to withdraw the, to dismiss our objection, the question therefore is, where is his antecedent supposed to be interrogated? Is it in this new matter, or was it supposed to be interrogated in the withdrawn matter? Because here we are looking at the antecedent of the accused person. In the event, Your Honor, that the antecedent of the accused person is interrogated in this particular matter, will it amount to the violation of his rights under Article 50 of the Constitution? Because how will he respond in a matter that is not before him? They can see that has not sunk well. Do you want me to come again? Yes, Your Honor? Let me drive it home.
It seems that we're right.
Your Honor, when you dismissed our objection yesterday, we foresaw this coming. And we knew that this matter would arise, and it would be the basis upon which the DPP would be urging you to find it as a compelling reason. His response as to why he was absent can only be found in that particular closed file. And he was never, there's no that opportunity as of now. Because the explanation for his absence can only be given in that matter file, in that other file. I can see I've driven you home now. Number two, Your Honor. Number two, Your Honor. Your Honor, Section 87 of the CPC is where that file found its rest. The DPP, in the proceedings before you, have not said that the reason for closure was the absence of the accused person. There is no such kind of provision. At least all these are judicial records. And the last entry, Your Honor, that appeared on the last mention, the DPP does not give the reason for the closure. The court says an order as spread case is withdrawn under Section 87A. And the only thing that the DPP did was to move the court to close. He never associated the closure and the desire to close to the accused person. There is no nexus between the accused person and the desire of the DPP to exercise its power under Article 157. That nexus is lacking. Therefore, Your Honor, to say that those proceedings should form the basis for the denial of today's bail would only be to subject the accused person to a process that culminates in violation of his rights under Article 50, well knowing that Article 50 is a protected provision under Article 25, a non-derogable right. So there is therefore no justification for limitation, as submitted by my able friend. There is absolutely no justification. You know, when looking at that limitation under Article 25 to 34, look at the functions the accused persons holds at the moment. One, he's supposed to represent the people of Jija constituency, and there is a legitimate expectation.
Again, I think
It is submitted on it.
so
If it's on record, Your Honor, I rest my case.
I want to just say this. I think I agree with Kelvon in one part. We are all equal before this court.
That's correct, Your Honor.
So let's leave it at that.
That's correct, Your Honor.
Anything else?
Well, the only last issue is the application to examine the Inspector, is an opponent in this miscellaneous application. And Your Honor, I would like to take direction.
No, I wish I could be this
Yes, I oppose. They have not stated the provision of law that gives them the authority to cross-examine the IO after we have submitted and relied on his affidavit. They have responded. So we oppose it. We can serve us in the application and the authorities so that we also respond adequately. But before that, Mr. Kebon wishes to respond on matters that we did not raise. Yeah.
There is something new that arose in the course of a response by our learned colleagues. That is with regard to these documents, an order from the High Court at Koimburi, which we was given a copy yesterday, where the accused person was released on a cash bail of 200,000 anticipatory and a surety bond of 500,000. Your Honor, even it's our submission, we are to reply that even though the court relied on this document to consider the accused person on the temporary release on bond yesterday, that this order really have no nexus with this case before you. I would not want to use the word mischief because I would not like it, but there must be a reason why our learned colleagues have deliberately failed to serve the application. We've served the order.
The order's application was served. It is even served.
Yeah, if that is the case, we still insist from reading of this order that there is no nexus and there is no mention of criminal case before you, as well as the criminal case number E715 of 2021. It is not mentioned. And so we submit to the court abandons this order because it is not related to this case. There cannot be an anticipatory bail, Your Honor, for a case.
Counsel is deliberately misleading the court. He is misleading the court. This is not an anticipatory bail. It's a bail that was granted by the court under Article 49. It's not anticipatory.
Whatever it is,
He simply said there's no connection. And I said it yesterday, I was only going to use that so that we delay the case until today when I was able to do the ruling. They're simply saying I should not rely on that, so don't get too agitated.
Protect Mr. Kenyon, please.
So my submission, Your Honor, as I have said, is that unless or until such a time when our learned colleagues have faced an order relevant to the case before you, this one should not be relied by the Honorable Court. A second issue, which is final about the issue, is relating to the question of explanation as to where the accused person was.
The counsel cannot respond on points of facts. He can only respond on points of law.
There was a question relating to counsel attempted to explain in his own capacity that the accused person.
You know, you object.
All right, let me just say what you want to say first. I don't see if it's a point that if it's not relevant, I promise you.
Because he can only submit on points of law in his response.
As I said, it's peculiar here today.
I do not know why my learned colleague, with due respect, wants to dominate the proceedings.
I have not dominated.
At some point,
Don't worry, if it's not a point of law, I will not fight it. But at least let me hear what you want to say.
So Your Honor, learned colleague has attempted to explain that the accused person was sitting a number of times, say 3 times, per week, and he fails to appear or to attend the parliament for 8 consecutive times, he risks losing the seat. That was his explanation. It's our submission, Your Honor. We reply to that. The accused person in criminal case number E715 of 2021 was represented by counsel. That counsel did not appear in court. He did not write to court.
That is prejudicial to our position because
He
we
did
do
not
not
write to
have an
court.
opportunity to respond. Those are matters of facts here.
He did not write a letter to court or to DPP
We object
or
to,
to DCI
may I be heard
who,
on objection?
or DCI who were investigating the case.
May I be heard on the objection, counsel?
From
Let him finish his point and then I will make your objection.
From 29th of August 2022, nothing, completely, no communication has ever been done to Kiambu law courts, or DPP Kiambu, or even ODPP Nairobi, or DCI headquarters. To get to
I can see, those are matters of facts. They are objecting to our application for cross-examination.
I was concluding with one sentence.
Counsel, the conduct is when one counsel is on his feet, the other one
You
sits
don't
down.
follow the conduct. That is why it's also
That's
very
the conduct.
I am addressing the court while you are addressing me.
It is important that when he responds, he sticks to the rules.
But you just budge him.
But I was concluding, just one sentence, by saying, at times that we need to ask ourselves, which one was more important between the accused person who is honorable member, which one is more important for him to appear before the sittings of parliament or to appear before the court? Which one carries more weight? Question which the court.
How shall we respond
That's
to
all.
those
That's all.
facts?
That's all right.
You can object.
You
Go
know,
ahead and object.
you can only insist that you give us an opportunity to respond to those facts through our application to
On
cross-examine.
on the last aspect, therefore, you can raise an objection and we will make it as part of the objection that they actually have.
Let's move on.
Matters of fact. There are things and there. These are matters of facts. You can respond to.
We almost obliged.
Yeah, Your Honor, to the application for cross-examination.
So your colleague is responding. That's why I'm saying it's peculiar.
I'm responding, I have made that application, so I'm just giving you the response. It was suggested that there is no legal provision for cross-examination, and you know, the provision is at Article 50. Article 50, sub-Article 1, K, sub-Article 1K. And what it says, you know, is that an accused person, the Constitution, every accused person, I don't want to read the whole of it, but has a right and a K to abuse and challenge evidence. So, you know, what is before us is an affidavit deponing to matters of fact, together with documentary evidence attached to it, which, you know, we pray that we be given an opportunity to challenge, especially noting that these are matters touching on another proceeding, which the court would like to be given the full facts, even the defense, to understand the circumstances, so that the court can have the full picture. You know, that application, cross-examination, is not prejudicial at all. It only serves the better interest of justice to lay all the facts before the court. And that
Just also look at section 153 of the Evidence Act. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing, and juxtapose it as the submissions made by counsel. We must oblige.
Your Honor, I'm not prepared to respond to the application. I have to go and read so that I also guide the court. I cannot stand here and submit on something that I'm not well aware of, because my work as an officer of the court is also to guide the court. So I pray for time to submit, make my submission.
That submission is totally off, because we made the application, the DPP responded to our application, we have made a rejoinder. Now, the DPP is saying, wait, give me a second bite of the cherry, let me go research and come back and exercise an existent right of audience. So, Your Honor, kindly make a ruling on the application which you made, responded to, and which you have given a rejoinder. Thank you.
Cross-examination. Right?
Yes, proceed.
So before I delve into bail and bond, that's the issue of cross-examination.
The cross-examination is on the basis of the affidavit deponed by the DPP, urging the court to deny our client bail. So it is relevant.
Your Honor, maybe just to mention, I read the evidence. My colleague, my senior colleague, does research on it. Really, I'm just trying to just think as to really where the proceedings are headed to, because the basis of the affidavit of the inspector, Mr. Makumi, who is in court, is the proceedings. There is nothing new we have introduced. Basically, a chronology of events. Chronology of events showing how the proceedings were conducted up to 29th of August. There is nothing new. So at times, from where we sit, we think that the defense would wish to take the court through unnecessary wastage of judicial time and another whole of proceedings, instead of allowing the court to retreat and make a ruling, which we will abide and respect. Your Honor, I think the application should be disallowed. Should be disallowed. There is nothing new. There is no basis that has been laid really for cross-examination. All the material is before you. And if, in the unlikely event that the court is inclined to allow the application, then we will be praying for time. The officer is important, he wasn't prepared for it. We are also not prepared for it because we have found an affidavit which contains everything. Contains everything.
Yeah, Your Honor.
Do you want to say something again?
We've had a very lengthy deliberations here as defense. And what we realized is that since we started these proceedings yesterday and also today, we've also been a little bit unfair to the court because we've really pushed through. There are too many things, and within a limited time, and also we've not been conducting ourselves very well. So, and I apologize.
You cannot impute that motive. We dissociate ourselves with the submissions made by counsel. To that extent.
No, there are those instances where we've done what is not necessary. So I think it's just to put it simple, and for the court just to focus on one thing, just the issue of bail. And to our mind, the submissions that you have made with regard to the affidavit, you have no doubt the court will have an opportunity to look at it judiciously. And any fact that is not clear, I'm sure the court will have an opportunity to reflect on it. So therefore, our submissions with regard to the application for bail and also for cross-examination, we are safe in your hands.
So we're basically withdrawing the application for cross-examination.
We are safe in your hands. Look at the
And only the only thing for examination is when you granted bail yesterday, can bail be granted on temporary basis?
You wanted your client to go in.
No, it's for today's termination.
Yeah, you know, the challenge is real.
As the PPP mentioned, I just gave you a brief as I did my review.
Sure.
So it's not based on that.
Sure.
I want to push it because they will push it.
Indeed. What you realize is that the deponent may not be around, and we might have to delay it.
Thank you for saving the question.
I have still quite a number of matters that you can see my immediate prosecutor is sitting there. So again, I think I have to give a date next week. Consideration unless you're willing to stay here until 9 or something. You check out all our time on these applications. We're used to running with the course list. Can you come back on Tuesday, 25th?
That's it.
25th? 25th of February.
You can come in the morning.
What time is morning? Most of you arrive after 10 anyway.
I was at 10
At 10. I think 10 is when we go to the
You know that, you know, you can run a vote to clear the list for the day. So that we can
Yeah, let me at least go through the follow-up. So ruling on the 25th of February, 2025, 10. I will extend the interim bail terms.
You must have lunch. You know, yesterday I offered buying this longer lunch. She declined. Today I'm still willing. The offer is still open.
I know I don't entertain you until she's done. So 25th.
You're most obliged. See you on 25th.
I hope that's the last application. I want to close this item.
Thank you.
Thank you.